Can you see if he has a license?
Yes, sir.
Let's see.
No,
Just all the standard conditions.
we
Do you want?
we have conditions in place for RUA.
We do? We have it already? Okay. All right. I think we're good. Do you want to set it for later this week to see what happens? Or do you want to do it far off? It's up to you.
No, let's see what happens. It's okay. I just wanted to maybe a quick reset. Yes,
Yeah.
that's okay.
Okay. Who's your last one?
Last one is Rivas, Judge. He's also in custody.
Take a breather here. The judge just laid out conditions that could literally make or break this defendant's freedom over the next few weeks. These early decisions usually fly under the radar, but they're the ones that determine whether someone walks out the front door or gets walked right back to a cell. Tiny rulings, massive consequences.
This is the one I approached DC late yesterday because I was pointing late. We're talking about that there was nothing in the DIMS about knowledge, that actual knowledge of falsity.
You have anything?
So what I found is nothing specific. There's been no case law specifically addressing that issue. But from what I found is that there is case law regarding the element of knowledge, where it has to be actual knowledge. Mere possession of an item is not enough to provide any type of actual knowledge, at least as prescribed under the statute. The statute controls, the language of the statute controls and explains.
Ladies, can you take a look?
Yes, sir.
And then I can just take a look and pop with them real quick, and then I guess let me thin the line and then we can explore it further. Okay, can you give me just a couple seconds? Let me thin them out because it's going to take a little bit longer. Hey, sorry, you can reset John so you didn't have to wait.
Yeah, but I reset and then he said that you wanted to.
Yeah, I'll monitor these. Okay. Hey, Judge, sorry to keep you waiting.
No, it's just, so I'm just reapproaching again on Rebus, the ID case.
Oh, okay.
So I spoke to the state, and so it seems like we're at a disagreement on this. And the argument that I have, Judge, I think I have something that is pretty compelling. There's a case law that I have called Fledging v. State, and that's not regarding an ID, it's regarding a check. But the court looks at the element of knowledge in it, and it talks about how possession of that forgery check is not enough to meet knowledge, because mere possession alone is not enough. It's similarly here, by analogy, a possession of this ID is not enough because it would create an absurd result. The purpose of reading the statutes is that the court must interpret it by its ordinary language. And the language says that it has to have knowledge, actual knowledge of its falsity. Now, if for some reason it's ambiguous, then it must be interpreted in a way that doesn't produce an absurd result. So if we interpret it to mean the way the state is interpreting, that mere possession is enough, then it would basically allow the police to arrest anyone that has the ID that has any type of dimple or any ripple or any type of defect in production, because that's what's happened here. The police officer's only basis for arrest was that the texture of the ID was wrong or different than what he is.
That's why they do licenses in special ways, so that officers know that they're fake or that they're real or fake, right? They have little, so they can sit there and they can do this. It's got special colors, special, diagrams on it to be able to ascertain whether it's fake or not. And in this case here, there's a piece of tape and the paper's kind of like coming off.
That's not what I actually read in the DIMS. So the police officer in the DIMS only says that the texture was off, that it was not what he was used to. But my point is kind of emphasis on that point, that even if it is produced in such a special way, production can still be defective for whatever reason, and that shouldn't subject you to deprivation of liberty.
But at that point,
the judge isn't buying the smooth talk for a second. This is a perfect example of how judges balance logic, the actual wording of the law, and plain old common sense. And trust me when a judge starts pointing out that the statute gives them the authority to dig deeper. That's your sign your argument is slipping right through the cracks.
That gives the person the right to investigate more. When something is amiss, right, that's the reasonable suspicion, right? The thing that gives them the authority to investigate further to see, hey, is this legitimate? Because if it was legitimate, then they send them on their way.
Agreed. But it gives the police right to investigate further for that offense, but not reasonable suspicion to arrest. And that's the thing, that the state would need to find that the reasonable suspicion for every element of the offense, and it's the state's burden to produce that. And they haven't produced anything to show that there was reasonable suspicion for the actual knowledge of falsity.
State.
So, Your Honor, a couple things. One, this was something that the officer again felt. It's not real. It easily became unglued. The officer's going to be able to testify that, well, this was not something that came to the Texas Department of Motor Vehicles. In fact, the defendant even said, yeah, I don't have a license. Mine's suspended. Lack of knowledge of the law is not a defense.
Right. Ignorance is never a defense, right?
And I would argue, Your Honor, we're not saying that this is just mere possession. We're not arguing that. We're saying if you take a look at all the facts and circumstances surrounding this case, there is overwhelming evidence that there was intent by the defendant to use that driver's license, because he gave it over to the officers when they responded to the accident. They easily could tell it was fake. It even unglued on scene. So there's enough.
Unglued on scene.
The thing is that I don't see that anywhere in the DIMSO of being unglued. And the fact is that
this did not have the same texture, was not laminated, or it was laminated, but was not issued by the state. Card easily became unglued while holding it and was clearly made from paper and laminate.
I think that there's enough to go forward.
Okay. All right. Sounds good. All right. Thank you.
For sure.
That speech right there was a life lesson wrapped in a legal warning. And the judge is absolutely right. A warrant doesn't care about your schedule, your plans, your family, or your future. It'll drag you out of a birthday party, a job interview, or straight out of your bed at 3 a.m. The message is simple. Handle your legal business before your legal business comes looking for you.
Judge, I'm here on Mr. Jerome Hunter. He has that BVR that you put on today's docket, so we can address.
Come up, Mr. Hunter.
Judge, his mom is also here. Would it be all right to have her come up as well? Judge, if I may? I explained to Jerome and his mom that the reason why he's here is because there was a reading from that he was past his 9 o'clock curfew on the 15th. I talked to him about it. He's a young man that actually has a pretty good future, Judge. He's got a football chance in college. Both he and his mom knows the severity of, your words in terms of him being home at 9.
She would be ashamed to ruin a potential football career because of criminality, wouldn't it?
So anyways, Judge, on that particular night, what had happened was it was still during football. I think football is over with now. So he made the mistake. He went out to go work out with football is it your cousin?
My cousin.
Your cousin. And that's where he was that night, Judge. I asked him if he could get something from the cousin. He's got some text messages going back and forth of them meeting at a park by the house, at a park to work out. And that's that. And I think that's the only violation he's had, Judge. I think both his mom and Jerome realized that, hey, cannot happen again. His mom tells me that she would definitely, he's never been in trouble,
Let's do this. I'm going to send you for a drug test, Mr. Hunter. Okay? Send him for a drug test. You're to come back, and then we'll go from there.
Yes, sir.
Okay?
Yes, sir.
All right. Just take a seat for me. We're going to send you right now.
Back there or in the...
Is there?
Judge, he is set originally on the 7th, so if everything comes back okay, we'll just take it. Okay.
It's on Mr. Serrano, Judge.
Serrano. With a C or with an S?
Yes.
So he has an evading out of court 6, and then he's got our case.
So this one is pretty straightforward. It's one where it's where Pennsylvania requested an extension, but it was for the entire 30 days. And because of the nature of it, another court would grant it. And so they've already stated to me that they wouldn't be able to pick up the time. And so I'm going to dismiss it. However, they requested that the court admonish him before I dismiss the case, stating that the warrants are still active and that, but he has 24 counts of failure to appear for retail theft. I mean, it is, and obviously the evading is an aggravating factor, but just admonish them.
Pennsylvania can't come here? I mean,
Not in time. That's what I mean. It's typically the court grants 3 days, but they need the full month. And so because it's not an aggravated offense, is you've never granted.
is it just like a retail, like
It's a
a,
failure to appear, but it's so many retail thefts, just the aggregate amount that it becomes a felony, but
Sure.
but it was issued out in 2024, 2023.
are they going to refile the hold?
No, the hold is still well, the hold is going to be released because we can only hold.
I mean, okay, so
But the
you're going
warrant
to
is still-
dismiss, are they going to,
Fugitive case because they're unable to pick up in the allotted time, but the warrant is still going to stay active. And so he can get arrested again. He can get arrested in Montgomery County or Liberty County or Galveston, anywhere. It's still active. So, I mean, he could get picked up in 3 days.
so I guess we'll just, at some point,
He made bond on the evading, so he's able to go back
Yeah.
today. I mean, and
surprised that they did, but with the fugitive case that they gave it to GOB? What? Yeah, they gave it to GOB.
they did.
Yeah, I believe he has court tomorrow.
He, I think,
So,
Serrano.
no, in 2 days.
Yo te voy a traducir para el juez.
Good morning, sir.
Buenos días, caballero. Buenos días. Buenos días.
You are wanted out of the state of Pennsylvania
Tiene una orden de arresto del estado de Pennsylvania.
for 24 counts of retail theft.
24 acusaciones de hurto de una tienda.
The state of Pennsylvania
Estado de Pennsylvania.
doesn't have the resources to come get you within the allotted time.
Y a venir a buscarte en el tiempo que le toca.
So they're going to end up dismissing or withdrawing the hold.
Van a quitar la orden de detención que
The thing
tienes.
that I want you to understand,
Yo quiero que entiendas usted.
that hold
Esa orden de
and that
detención,
Pennsylvania warrant
esa orden de arresto que
will
tiene
always remain active
todavía y va a quedarse siempre activo.
until you go take care of it.
Que usted vaya ahí y
You
termina
could
de ser
literally
cargado.
walk out of here and they can rearrest you.
Literalmente puedes salir de estas puertas y te pueden agarrar